When doing your estate planning, should you use what we call a family member fiduciary? In other words, should your executor, often called the trustee or a personal representative, should that person be a family member? Now, the answer might well be a resounding yes. But before you make that decision, you have to understand some risks, some things that just could come up through the course of administering your estate or your trust. So number one is that a family member fiduciary will have a tendency to do what I call dive right in. So for example, if your estate plan gives a house to your child, your trustee or your personal representative may simply do just exactly that, deed the house to the child. So what's the problem? Well, the problem there is that in this case, the family member fiduciary has missed some really crucial steps. What about notices to trust beneficiaries? Notices to creditors could be known creditors or even unknown creditors. What about an inventory of assets in the trust or the estate? How about an accounting of income and expenses? Now, it very well could be the case that no liability ends up coming out of this misstep, out of missing some of these notices and steps and things like that. However, it's important to remember a disgruntled beneficiary can still use this as a technicality as a way of coming at the fiduciary in the future. Number two problem I see with family member fiduciaries is risk management misses. So earlier I mentioned notices and accountings and reports and things like that. So not only are these legal obligations, but they're also risk management tools. For example, in a trust, an initial notice to beneficiaries can actually limit the period of time in which the trust can be challenged to a period of just 6 months. In another case, trustee reports or accountings can actually limit the right to bring claims based on information in that report just to within a 1-year period from the date of the accounting. Now, a lay fiduciary is much more likely to miss these steps, especially when they're not being represented by a competent legal counsel, which brings us to point number 3. Going it alone without counsel. This is another huge problem I see with family member fiduciaries, especially and almost exclusively, really, when you're talking about trust situations. And why is that? The trust is done outside of court most of the time, whereas with a will, it has to be filed with the probate court. A trust doesn't. And so oftentimes with the trust, the family member trustee simply does not want to use legal counsel. Oftentimes they don't want to incur the expense. They're concerned about what those costs are going to be. And so they figure, hey, no court, no lawyer, right? Wrong. The first two issues I mentioned with the risk management and the technicalities, those things are oftentimes directly missed simply because the trustee decided to go it alone without legal counsel. Now, a family member fiduciary could very well be the right choice for you. But it's really important before you make that decision to make sure that your family has a relationship with a trusted community attorney like us over here at Fausone Grysko, somebody that can help them out when they get into a bind, when they're administering your trust or your estate, to make sure that they don't miss these things and other things that are very commonly missed. The Michigan Trust Code, the Michigan Estates and Protected Individuals Code is probably hundreds of pages long, and I'm guessing that your family member fiduciary is not an expert in that area of law. So go ahead and check us out on Facebook at Fausone Grysko or on the web at thefgfirm.law or give us a call at 248-380-0000 and find out how our trust and estate legal team can help you.